for joining us today. We're going to get started and talk a little bit today about. We've touched on this topic in the past, but one of the things that is very interesting about estate planning and legacy planning and incapacity planning, and the things that we talk about on this podcast are there's so many aspects to these topics that I think there's something worth learning in relation to multiple scenarios or situations that we can find ourselves in. And today we're going to talk about specifically protecting your children in the case of incapacity, or in the case of the parents becoming incapacitated. And sometimes we imagine that as long as we're alive, that we're going to be able to be there for our kids, make sure that they're taken care of, that there won't be a need for somebody else to step in and take a more active role in raising them as long as the parents are still alive. But there are situations that can come up that, the parents don't pass away, but because of incapacity, that there is a need for somebody else to step in as the decision maker on behalf of your children. And so we'll talk a little bit about how that works, but let me share with you a story. And this is a sad story, but it's a true story. We have a client of ours who had early onset Alzheimer's. Now, for those of you who are familiar with Alzheimer's, you know that Alzheimer's usually starts in maybe the mid to late 60s. And it's a very devastating disease. It affects your mental capacity. It affects your ability to, handle day-to-day affairs sometimes. It can affect your memory. There's a lot of things that, that can be impeded by Alzheimer's. And generally, somebody who's younger doesn't get Alzheimer's, but occasionally it happens. So in this particular situation, our client had early onset Alzheimer's. He was in his early 40s. And he had a daughter who was about, I think at the time, about 7 years old. And, it's important because when we talk about, the process of somebody being diagnosed with Alzheimer's, at the beginning, they're aware of the diagnosis. They're aware of the changes that they're feeling and that they're, kind of going through. They have a lot of capacity to be able to stay involved, and they don't really feel that they're losing control of their life right away. And so it can be a very difficult process to accept. And for the first year or so, that was the situation he was in, was that he felt like he was capable of doing all the normal things that he would normally do, but slowly he was becoming incapable of doing those things. And so during that process, we were helping his wife to be able to, try to get access to accounts and try to make decisions on behalf of the household and be able to take care of him and so on. And unfortunately, he had done an estate plan years before he even got married, that had named his mom as his power of attorney. And the mom never got along with his wife. And so even though she was named as power of attorney, it didn't really help the situation because, mom had access to accounts and wanted to exercise the power of attorney and retain control over everything. But she didn't want to give anything to the wife, and she didn't want to provide for his child, which is a pretty, intense position to take. That's the position that she took, right? And so we were fighting things out in court. But what it comes down to was that he got to the point where he would wander from the house while his wife was at work. He was supposed to stay at home, but he would leave the house and go looking for his daughter at the school. So he'd walk to the school and then he'd be wandering around the school. And when the police would find him, they would ask him what he's doing there. And he wouldn't really be able to tell them because he said that he didn't remember, or he would say that he's picking up his daughter from school, but it wasn't time for school to be out yet. And so they thought that he was a danger to the people who were who were at the school, right? And so he kept getting into trouble every time that he would wander over there, and they'd accuse him of different things. And so, that situation was a situation that just couldn't continue. And the wife was just getting overwhelmed. And so she finally said, well, we need somebody to be his caregiver on an ongoing basis, a regular basis, so I can go to work and then somebody can stay with him. But she didn't have the income to be able to pay for that. And the grandmother, his mom, was the one that had control over the accounts and over the money that should have been providing that, but she refused to, right? And so, it's very important to make sure that you have certain documents in place before these types of things happen. And if you've done a plan, like a power of attorney, a trust, or other documents, if you've done those things beforehand, it's important to make sure that when you have major life changes, such as getting married, that you update your plan, right? And unfortunately, in this situation, that didn't happen. And what we were able to do was, while he still had consciousness, he was still, had some capacity, and he understood his situation, even though he had already received his diagnosis, we were able to have him sign a new power of attorney and give, authority to his wife. And some of the institutions accepted that, and some of them didn't, because there was a contesting power of attorney out there. And so, ultimately it was up to the court to decide whether our new power of attorney was valid. But we had, a doctor's letter saying that he had limited capacity. We also enough capacity to be able to, to sign the power of attorney. We also had, the documents themselves. We had witness statements. We had, a lot of evidence on our side to be able to contest the grandmother's power of attorney, because the new power of attorney should have been controlling. So, that is something to consider, especially in a situation where you see incapacity creeping up on you, to act quickly and get something in place, especially if the family's all on the same page. That makes it even easier. But that's an important time to do it, because otherwise everything ends up in the court system. And the processes that we look at are a guardianship or a conservatorship. And depending on the state you're in, some states will call it a guardianship for all decisions over your person and your health and well-being. And then they will call it a conservatorship for all decisions related to finances. And some states call it a conservatorship over the person for all decisions over you, and then a conservatorship over the estate for all decisions over finances, right? But either way, it comes down to the same thing, which is basically a court process that takes away your rights to make your own decisions and gives them to someone else in order for them to help make decisions that are necessary, right? And in this situation, that's ultimately what we had to do, because the documents themselves were not enough to be able to settle the issue, right? We needed a court to step in and make that decision. So one of the things that's very important is if you have minor children, having a plan for yourselves to make sure that not only is there somebody authorized to make necessary decisions for you, but in that situation, if he would have been a single dad, just imagine who could have taken care of his daughter. We've seen, movies like this, right? There's movies out there that you could watch about this very issue of, a parent that's maybe become incapacitated or was never really had capacity, but they're left as the responsible party for a minor child. And what happens then, right? And a lot of times the state will get involved, and they will take control of the situation. They'll take control of the child and put them in the foster care system. So instead, it's important to name the guardian for your children. But a lot of times we talk about naming the guardian for your children when you die, putting it in your will. Well, it's something that's, a nuance, but it's important to know, is that you can also name the guardian for your children in your financial durable power of attorney. In your power of attorney, you can say, in the case that I can't make decisions for my kids or take care of them, this is the person that I want to step in. You could even have a declaration that's, a separate declaration of guardian to say, in this emergency situations, or if I become incapacitated or whatever, this is the person that I want. And it's a standalone document specifically for that reason, to say, this is the person that I empower to make decisions on my behalf for my children, right? And I think that's a very important thing to remember. And it's also something that we recommend for people who travel a lot, because if you get caught outside the country and you're unable to come back, or you're unable to, do what's necessary, there will also be a need for somebody to step in on a temporary basis as the guardian or as the decision maker for the children. So another thing to consider. But when we talk about, naming this guardian, you want to name the person that is going to be the best fit to take care of your children, to make sure that they can accommodate things. And it doesn't necessarily have to be on a permanent basis. Imagine that somebody, let's say one of the parents or both parents, are in a car accident. And we've seen this happen, right? Where somebody goes into a coma, they're unconscious, they're out of it, they can't make any decisions, they're pretty much, a vegetable for a period of time, 2 weeks, a couple months, and then they come out of it and they regain consciousness and they regain their ability to make decisions and so on and so forth. If in the meantime somebody has stripped them of all of their rights, then it becomes a difficult process to, get back to the way things were, right? But if in the meantime somebody was empowered to make decisions on a temporary basis, and then you regain capacity, then they, all the rights come back to you automatically, more or less. Then that is a better process. And so those are the types of documents that we can put in place to be able to allow for that sort of thing. The other thing that I think is very important to consider is when you have a child that gets to the point where they turn 18, they have the same problem that you do, which is if you were incapacitated, or if you couldn't manage things for yourself, if you weren't able to make, necessary decisions for your everyday life, nobody is automatically empowered to do that for you. You have to have proper documents in order to empower that. And once your children turn 18, they have the same dilemma, because if they find themselves unconscious, and this actually happened to my sister in her second year of college, right? She wasn't married, didn't have any property, didn't own any, anything of real value. Most people probably would have thought that she didn't need an estate plan at that point in her life. But she did find herself unconscious in the hospital at one point. And, the hospital called my parents and they asked them if they had a power of attorney or a medical directive or a HIPAA authorization or anything. And, 80% of Americans don't have anything like that in place. And my parents didn't have anything like that for my sister. So they said no. And the hospital told them, well, your daughter's here, but we can't tell you anything. She was 19 years old. So as a 19-year-old, she's considered an adult. My parents no longer had the ability to make decisions on her behalf without her authorizing them in writing. So these powers of attorney are important to have, not just for yourself, but also for your children once they turn 18 and they're considered adults under the eyes of the law. So again, a few things to think about. Incapacity planning is one of those things that, as much as most of us never want to have to worry about it, the likelihood, the percentages of statistics is that you will need to think about it at some point in your life. Over 72% of us will live long enough that we need long-term care at some point in our life. And that may be because of an undue accident that happens to us and we're in recovery. Or it may be because of Alzheimer's or dementia that hits us in old age. Or it may be because some debilitating illness, comes to us. I have a friend of mine who has MS, and for years and years it was in remission, but now it's gotten a lot more severe, and there's a lot of day-to-day things that he couldn't handle by himself. And luckily for now, his wife is able to handle all those things. But situations for every family can be different. So it's important to have the right documents to empower somebody to step in, to make decisions, to handle things as necessary when these emergencies come up, because you don't want to be blindsided and end up in the court system. And the last thing I'll share with you is we had a lady who had contacted us, She's in Texas. Her husband had a stroke. And as part of the stroke, he was unconscious for a period of time. He finally came to, but he was unable to handle any of his day-to-day, sort of needs. He needed somebody even to help him to get up, to be able to get dressed, to be able to eat, and so on and so forth. And when he was in the hospital was making all the decisions. The wife comes in and she says, well, I think I want him to come home. And the hospital says, no, we can't send him home. And she says, well, don't I get to make that decision? And they said, not unless you have, a power of attorney, or not unless you have something in writing, or unless you go get a guardianship. And so she said, okay, well, I'll go get a guardianship then. It's taken 2.5 years for her to be able to get a guardianship in place. And during that time, they have sent him home and so on, and then he's needed additional care, and she's been providing that. And but during that time, she says, anytime there's a major decision, I don't get to make the decision. The hospital, the doctors, the processes that our systems have in place, they make the decision for me, and I feel so powerless. I can't do anything about it. And until this guardianship gets finalized, it took her 2.5 years to get the guardianship in place. So that's the kind of stress that you avoid by having even simple, basic documents, proper documents in place. So we invite you to consider your planning, make sure that you have things in place to avoid these sort of problems, and to make sure that your loved ones are taken care of. And if they have problems, that you also are empowered to step in and handle those issues without any dilemmas. So thanks again for joining us today. Make sure that you subscribe to wherever you get your podcasts to our show. That way you can get the latest and greatest as we have new shows that appear every week. If you're watching this on YouTube, subscribe to our channel. We love to hear from you, and we'll see you all next week.